Okay. So I would say that I have 12 on mine. So Billy, Kathy, you all take it over. Billy, I'm going to turn it over to you.
Okay, that sounds good.
Bye-bye.
Thank you. See you, Sandy. Okay, I think we're going to roll. If you guys are good with it, that way we can stay on schedule. Okay, welcome everyone, and thanks for joining us today for our New Knowledge session. New Knowledge is a series of professional development and workshops for supporting business owners, nonprofits, and citizens in not only Washington County, but around the Commonwealth. My name is Billy Roberts. I'm with Virginia Community Capital. We are a community development financial institution providing lending, investing, and community innovation services. We are happy to partner with the Washington County Chamber of Commerce, Virginia Highlands Small Business Incubator, and the town of Abingdon to present this business and organization skill development. Today's session will be recorded for training and educational purposes. Now, before we get started, I wanted to note that to keep the webinar flowing and to stay within our hour goal, we have muted everyone. However, we do want to hear from you and ask that you please post your questions in the Q&A section that's at the bottom of your screen, or you can also put it in the chat. I'll be monitoring those for you, Whitney, okay? We will address your questions during and after the session. I will now turn it over to my co-host, Kathy Lowe with the Virginia Highlands Small Business Incubator to introduce our presenter and moderate our session. Hi, Kathy.
Thank you, Billy. I am very pleased to have today one of the tenants at the incubator and actually one of our success stories, Whitney Pennington. Whitney has been here for just a little over a year and has already had to expand into another size office, and we're very proud of the work she does. So without further ado, Whitney Pennington.
Good afternoon, everyone. I hope you're at least getting to enjoy lunch while you get to listen to me talk. My name is Whitney Pennington. I've been an attorney for about a decade now. I've practiced in a number of locales and opened my firm last year in 2022. I am at the Small Business Incubator, and the focuses of my law firm are family law, but more importantly for today, estate planning. I'll try not to make it dry. I know this can probably be a little overwhelming. People don't like to think about this in terms of their end of life and planning, and I get a lot of deny and avoidance. But I would encourage you to think about this if you don't have a will or it's been a while. Think through some of the things I present today, and if something dings a bell, please feel free to ask a question, and I'm happy to answer it to the best of my ability. I will say that there's no way that this can be comprehensive and address every concern that everyone has. These are just sort of broad principles in terms of some estate planning things you probably need to be thinking of. I did send a packet of information along with this screens for this to Sandy. Hopefully we can get that out to everyone. The packet really goes through and reiterates everything I go over today. And at the very end of it, it helps you start thinking through some of the things we talk about today. So maybe, if you're looking at making an appointment or going to discuss something in terms of estate planning, you're better prepared. So let's sort of, hit the deck running. We're going to talk about wills. I'm going to touch on trusts a little bit. Trusts we could spend a whole other hour on, but I won't do that to you. There's powers of attorney and advanced medical directives. And when we're talking about estate planning, I usually recommend a will, a power of attorney, and an advanced medical directive at the very least. So I often get asked, why do I need a will? Why is it important? If I die, the state will just determine where my stuff goes. So sometimes I have seen people who quite frankly were wealthy business owners who thought they had years and decades to live, and they passed away. I've recently seen that within the last year, where someone passed away. It was a blended family, significant assets, many businesses, and no estate planning was done. And so that created quite the nightmare in many, many layers in terms of what happens to these businesses. How do they, where do their assets go? Who gets them? Now it's divided between a blended family. There's a new spouse. There's children from the prior relationship. So needless to say, it is and was messy and continues to be so. So I would encourage you to sort of think through these, I guess, questions as I bring them up. When we're talking about a business, of course, there's tangible assets and intangible assets. Tangible, obviously, like your desks, your computers, your things that we can touch, we can feel, we can sense. And then there's the intangible version. Maybe it's stocks, maybe it's some type of investments you have in your company. Maybe it's the goodwill of your company. Maybe it's shares you own in the company if you have multiple partners within your company. So those are the assets you're sort of thinking of in terms of your business, along with your personal assets as well. I recently did some estate planning for a business owner who wanted the tangible assets to be given to a particular person, and the intangible, like the shares in the company, went to other people. So it can be divided. You've got to think through those things in terms of who's going to get what. We can always deal with specific property, and in my wills and in Virginia, if you leave a specific written list, this only deals with personal property, but I include it in all of my wills because I find when people come to meet with me, they're super overwhelmed by the idea of, I have to have everything laid out. Who's getting what? Who's getting grandma's ring? Who's getting great grandmother's quilt rack, or whatever it may be in your case. Or maybe you have a car collection or a gun collection or whatever it may be. And that overwhelms a lot of my clients. And what I have found is I include this paragraph that Virginia allows me to do. And it basically says, whatever, if you've got a list that you leave at the time of your death, it's in your handwriting, signed by you, and it deals with personal property, and that's kept together with your will or your trust or whatever it may be. As long as those items are kept together and they can be validated, then those items, even if you add them on 2, 3, 10 years later, as long as it's kept together in that format, those will all be put together and your wishes will be accepted. So, that sometimes that alleviates the stress and the pressure that my clients feel when they come in. And I use that quite a bit. And so far I've had no issues with that in 10 years. The other things to sort of think through is not only who's going to get specific items, or if you're a business owner, of course, who's going to get the business assets, what's going to happen to the business. I call it the residuary of the estate. Basically, it's the big bucket that's left over. If you don't specifically deal with a certain piece of property, your home, your business, whatever the case may be, and in this case, it would be, I guess, be your business shares, then it goes into what I call the big bucket, called the residuary of the estate. And then you have to designate who gets that big bucket. In other words, after everyone receives your full list of property, the rings, the coin collections, the house, whatever you decide to do, who gets everything that's left over? This can be one person. This can be multiple people. It can be in unequal shares, equal shares. There's many different ways to skin that cat, so to speak. So you kind of have to think through who you want to get that big bucket. I think that's the most common way to kind of put it in my law firm. I think it's simplest to put it that way. So you're looking at that. And so if you have a will and you own a business, and perhaps you haven't dealt with the business specifically in the will, then that would fall to this sort of big bucket at the end, and whoever you name would take their share, or that would pass to them. In terms of who handles everything, once you pass away, you usually name an executor or an executrix in your will. That's the same basic thing. Unfortunately, or we have a different executor as male, executrix as female. It's the same duties, same responsibilities, same thing. It's just a different name for male versus female. The executor is incredibly important. This person has to be responsible, has to pay attention to detail, has to be someone who can really work well and play well with others, and needs a level head, because this person, if you have a will, is going to be in charge of accumulating whatever you have in terms of personal property, real property that needs to be disposed of. And they're going to be the ones responsible for accounting for it. Every penny must be accounted for, who gets what and when. It is very, very detail oriented. So I encourage my clients, especially if you have a business, you need someone who is very good with numbers, very good at keeping track of documents and dates and receipts and what's been spent, and what's been passed out to the heirs. That person really needs to be well selected and well thought out. The other thing that I would encourage you to think about in terms of some estate planning and just overall planning for your business is the operating agreement. The operating agreement usually lays out who your members are, who your managers are, however you're set up, who's in charge, essentially. It also lays out what happens, ownership interests, if that's not clear, who has what shares or stocks in your company. Of course, those have value and need to be disposed of. One way of perhaps dealing with that is an operating agreement. And that can deal with when you pass, where do your stocks, shares, and interest in the company go? So I encourage my business owners to have a pretty solid operating agreement if that's something that they're looking at globally. I think it's good business to have it, because what happens if the business goes, something happens and it has to be terminated? How do we wind that down or dissolve that business? And that operating agreement can also be good for that as well. I know that is a lot of information, but the gist is you really do need a will if you own your business. And especially if you own multiple businesses. If you don't, always get asked that question, what if I just don't do it? Well, then you're letting Virginia decide who gets what. And in cases where perhaps you've been married to your high school sweetheart for 50 years and there's no issues and you have your children and everything's honky-dory, there probably won't be too many issues, maybe. However, if you have divorced, separated, your spouse is deceased and you've remarried, that is when I see the most issues. It's the blended family, because by law, 1/3 goes to your spouse, your current spouse, and 2/3 goes to your children from the other marriage. And so sometimes there's this conflict between the current spouse and the children you have from a prior relationship. So you might not think that that's a big deal now, but I will tell you, most of the people who call me, that is the issue we're having is dad, mom, remarried, there's no will, and now we're, duking it out over assets and who gets the home, and it can get complicated and sticky fast, especially with my blended families. So nothing against them. I think they're beautiful and wonderful, and they certainly work well in many, many ways. And but I also do encourage you to think that through in terms of planning. And certainly I will say grief brings out the worst in us. It's very hard. And sometimes you're like, my children or my spouse would never do that. And under normal circumstances, you're probably right. But when we're dealing with a death, especially if it's sudden or unexpected, people don't act rationally. They don't act in a way that you would anticipate or expect. Which can be hard for people to deal with and wrap their minds around. So I will very briefly touch on trusts. Again, I could spend a whole nother hour on that, but often I get asked the question, what's the difference between a will and a trust? Even if you have a trust, you still have to have a will that basically goes on record and takes whatever you own at the time of your death and puts it into the trust. So you still have to have a will, but the trust kicks in. And very, very briefly, I am not a CPA. I want to put that out there. I'm not a CPA. I am not a tax attorney. I'm not an accountant. I cannot and usually don't give tax advice. So especially with my clients who have a larger portfolio of assets or there's questions about taxes, I certainly encourage you and will work with your CPA to make sure we make the best decisions that benefit you, not only in your estate planning, but also for your taxes and protecting you and your family. There are tax, benefits. You're not taxed in the same way if you have a trust. When you have a will, traditionally, they look at the value of your estate and they tax that. There's different tax rates for different counties. I'm not going to presume to be able to tell you what your county is going to be, but it can be different and fluctuate within counties, perhaps. And just know, though, that they look at the total value of your estate and they will tax it based upon that locally. And then, of course, there's state and federal as well. So sometimes we can do some tax shielding or even dealing with perhaps some capital gains issues if you own like rental properties. That is something else that we also have to think about is if you put the property into the trust, can we maybe avoid some capital gains when your selected beneficiaries inherit that property? So I encourage you to think through that. A trust isn't always necessary just because you have a business, and a trust isn't always necessary because you have, a good size portfolio. But I do get asked that question a lot, so I thought I would throw that out there. Another reason sometimes I have people simply select it because there's limited oversight in the trust process after you pass. So everyone hates the idea of probate. I get a lot of questions on that. I don't handle probate right now. But I've been an executrix. I was for my grandmother. And I know how painstakingly, not difficult, but time intensive it is. And even as an attorney, having the knowledge I had, I mean, I didn't enjoy it. So, I could imagine someone kind of coming in here who has no legal background, being very overwhelmed. And the trust sometimes makes it simpler because there's less state oversight. There's less documents you have to file. It tends to uncomplicate the probate process some, because your selected trustees will essentially take over, and the trust document will tell what happens when you pass. So a lot of people like it for that reason. The other thing is your ability to sort of control more after you pass. So typically when you're dealing with a will, you have to just basically give it outright. And there's this big old rule that I will not go into that bores everybody. But basically, we're trying to prevent you controlling property beyond the grave to a certain extent. Trusts give you a little bit more ability to control, like if you want to give your home to someone and they have to meet certain qualifications. A trust is probably more appropriate for that. A will, you really is not designed for that purpose. I had recently a couple come in who were really fun, and they wanted a trust because they were concerned about what would happen after they passed if the other one remarried. And they wanted to protect their assets and make sure that we really got it nailed down. Really quickly, another question I get sometimes is, what's the difference between revocable and an irrevocable trust? I would say 9 times out of 10, I would recommend a revocable trust. The difference is one can be changed, modified, or completely dissolved, which is revocable. An irrevocable, once you establish that, once you set those parameters and give whatever property you're putting in that trust to somebody, you can't undo it. So if that person ticks you off 2 years down the line, you're stuck. So most of my clients choose a revocable trust. There are benefits, again, that we could discuss more at length, but overall, the positives to the trust are, 1, the tax benefit, limited probate, and your ability perhaps to control your property a little bit more after you pass than you would in a will. All right, powers of attorney. I always recommend these. I give the example of my husband and I have a power of attorney. We bank at a local bank. They know us both. My husband had a fraudulent charge on his account. They know me. I'm on the account. I couldn't fill out the paperwork for him to try to void the transaction or dispute it. They had to have my power of attorney on file. So I had to remedy that. But people are like, what's the point of a power of attorney? And what do they do? So there's different types of powers of attorney. You can either make them, there's kind of 2 main categories: springing or automatically effective. A springing power of attorney comes into effect when you're incapacitated and have been deemed that by your doctor. We can put parameters in place. So the power of attorney wouldn't kick into place until you had been deemed incapacitated mentally and not able to make decisions. The other is just a straightforward, it's effective now, no ifs, ands, buts about it. You can select who you want to select. Often my spouses do each other first and just make it automatic. That way, in my example, I just take my power of attorney. It's automatically effective for my husband. I hand it in and I can act on his behalf if I need to. The decisions that they make, this is a financial power of attorney. Mine are relatively long. I will say, if you're not expressly granted that power, or it cannot be reasonably construed from that document that you have that power, you can't do it. So really, you have to make sure you have got every power listed to the best of your ability, and it kind of written broadly to be able to handle that. So I encourage people to think about their powers of attorney. If you have one, pull it out, see what powers were granted. If it's 20 years old, maybe it's time to update. You need to think through who you're going to select. Again, that kind of goes in that line with the executor. It needs to be someone mature, level-headed, reasonable. And I do a durable power of attorney. A durable means that it lasts even if you are deemed incapacitated. And why is that important? So say you do a power of attorney today, and let's say you have a traumatic brain injury or a stroke or early onset Alzheimer's dementia, and you lose the capacity to make decisions. Well, if you don't have a durable power of attorney, the issue becomes you have no one who can make decisions because that power of attorney stopped when you became incapacitated. Whereas a durable one lasts until you pass away, or you could change it if you have capacity. So I always encourage people to have that, to think it through, because I get this call a lot, and this is why it's important. And I cover it here and also on the next slide. But so what happens if I don't have a power of attorney or advanced medical directive, which we cover here in the next minute or so? What happens? So what? Well, if you don't have someone who has a power over your finances or over your person by an advanced medical directive, then your family, your loved ones, your spouse, your sons, daughters, or whoever it may be, is put into a position where they have to petition the circuit court where you live. So I'm in Abingdon, I would say Washington County for myself. You would have to petition the circuit court. There'd have to be a guardian ad litem appointed for you, the incapacitated individual. Notice has to be sent out to all of your family members. You have to have a doctor sign off and have that evidence to even file that you were incapacitated and no longer able to make these decisions. And we go from there. I mean, you have to have someone appointed by the court. There's significant attorney's fees in there. It can get contested, especially if multiple members of the family want that power over your person, your finances. Whereas if you go ahead and make those elections now, it's taken care of. It stops the squabbling. It stops anybody from coming in that you don't want them to come in and have control over your power, your finances, or your person. So I always recommend that people have that, because, I get these phone calls too, mom, dad, grandpa, whoever doesn't have a power of attorney or advanced medical directive, and they need care. They need to go into hospice, rehab, some type of facility, a nursing home, whatever it may be. And they can't do it because legally they don't have the power to do it. And so we get into this vicious cycle of we've got to get into court fast. And, then you're dealing with a court's docket and a judge's docket and everyone's calendars. And, a guardianship and conservatorship proceeding, which is what that is not an overnight, fix. It's not something that I can just walk into court and file and by end of week have a resolution for you. Doesn't work that way. And so meanwhile, your mom, your dad, your grandpa, your grandma, whoever, you are lying there with no one having the ability to make financial or medical decisions for you. And that really puts you in a bad position, or can. So I always encourage everyone to think that through. It's really simple to do now. I always choose, I designate a first and I do an alternate. So if the first person, like in my case, if my husband cannot do it because he is himself incapacitated or he's unavailable or he predeceases me, then, my alternate would be able to make decisions, and it just continues to flow. If you don't have an alternate, then you're stuck in that same scenario I just sort of listed, if the person that you name first can't act. An advanced medical directive, again, just think of these as like financial power of attorney, and then your power over your medical and your person. My advanced medical directives are kind of a 2-for-1 document. I contain a living will. If you've heard that terminology, if you go to the doctor, if you're getting ready to have surgery or some procedure done, they usually ask, do you have a living will? And I provide that to my clients. A living will is essentially you are in a vegetative state, and a doctor has confirmed that basically life support is just keeping you alive, and it's your wishes that support be removed so that you may pass peacefully. If you go ahead and make that designation, that alleviates that burden off of your family and also makes your wishes known. You don't have to have a living will. We can completely take that part out, but most people prefer that portion. The second portion of the document is really known as the advanced medical directive. And that portion selects or designates a person to make decisions for you. Now, the big difference between this and the financial power of attorney is this advanced medical directive does not kick in or become effective until you lose capacity. In other words, until you cannot make rational decisions about yourself, your health, your care. Until that happens, you are in complete autonomy of your body and your care and your decisions. You may not be making decisions we agree with, but as long as you have capacity and a doctor says, we don't agree with these decisions, but it's her body, meaning me, or your body, then they're able to do that. So, this doesn't kick in until you completely incapacitated. I believe 2 doctors have to verify it. There's certain things that have to occur before it becomes enforceable or valid. So I would look at that. I always encourage people to have it because you never know when you're going to lose capacity. I mean, I'm relatively young. I'm 36 this year. And, I could be in a car wreck tomorrow and have a traumatic brain injury or TBI and not be myself. I could lose capacity. Parts of my brain could be affected. And so even though if we're young and we think we're healthy and we've got forever to take care of this, we don't know what's going to happen. We could step out and be hit by a car, or something could happen to us, which causes us to not be able to make medical decisions on our behalf. So if you're young, if you're middle-aged, if you're older, whatever the case may be, these are advisable, because I have had people come in and call who, they were relatively young and now they're in this predicament of what do I do? Because, my spouse didn't take care of this earlier on. I think we've addressed sort of 1 and 2. Who do I select? Again, the constant theme throughout this is who do you trust? Certainly you don't want to select someone who's flippant. Certainly you want to select someone who has some knowledge about perhaps your medical history, where you're at now physically, your wishes. That's also going to be important for whoever you select. What decisions can they make? Again, whatever decision, it has to be specifically enumerated or given. That power cannot just be assumed, like, oh, that person wanted me to be able to do that. Well, it needs to be fairly enumerated. Both my advanced medical directive and my financial powers of attorney are quite lengthy. Both are a little less than 10 pages, which is quite a bit. I mean, I'll admit, but I would rather you have the power to make the decisions that you need, or whoever you select, than not, or be in this predicament where you're stuck and you have to go through the courts to get the power you need. I've touched on what happens, if you don't have a power of attorney or advanced medical directive. Those cause a lot of issues and definitely can impede your ability to receive care or financial assistance or whatever the case may be. So I strongly encourage people to think through the wills, the powers of attorney, and the advanced medical directives. I know that is a lot of information and I talk fast. I know. But that is probably the nuts and bolts of what you need to be thinking of in terms of owning a business, in terms of your assets. I meet with my clients usually at least an hour when we're estate planning to walk through all of this. I know it can seem daunting. A lot of my clients are overwhelmed by this notion of having to plan these items out. And I understand that. No one wants to think about what happens after they pass away. But for the sake of your loved ones, you really do need to be having these conversations, especially if you have the added layer of owning your own business. It's important to denote who is going to handle that, where your shares are going to go. You would rather have control of that now and dictate that now than let either someone else or the government say where your stuff goes. I think that's one of the biggest selling points is you retaining autonomy over the things you've worked hard for. We, as a business owner myself, although recent, those of you who have been in this for quite some time, you've worked hard to get to where you're at, and you should be able to decide who gets to benefit from that hard work. So I really encourage you to think through, and what I've said, perhaps something struck a line with somebody, but really I'm here. I think that's my email and my phone number, my office phone are on, I guess it's being, yeah, you can see the screen. So, and also Sandy's going to send out that packet I mentioned. It goes over everything I just discussed, but in written format, so you can read it. And of course, at the very end, it just starts listing things to think about, like who would you want to be executor? And you can write it out, gives you a space to do that and start thinking through these issues. So I encourage you to look through that packet. Hopefully Sandy can get that out by the end of today or in the near future. Review it. Again, it might cement some of what I've said today and help you start making those determinations now. I think we have a question maybe or a comment.
Yep. Can you see it, Whitney, or do you need me to read it off for you?
I can. Oh, sorry.
Let's read it.
Okay.
So
Let's read it out loud so that everybody can hear it. So if I have a will in another state and now live in Virginia, does the will have to be reviewed for Virginia laws, or am I okay with the will from another state?
So I get that question a lot. People travel, people move. I mean, we're not sedentary. We go from state lines. I lived in North Carolina at one period of time. But the state in which you die in is the state in which you need your will to be valid. You cannot, if it's valid under California. I had a wonderful client come in, and her spouse had died in California. We reviewed the wills, and unfortunately it did not meet Virginia's requirements, so there was no valid will. That was very hard, but that's a wonderful question. If you're living here, and if you are here, yes, certainly you need to have it. Make sure the will is valid under Virginia law. Just because it's done somewhere else does not automatically mean it's not valid here, but Virginia does have strict requirements for a will to be accepted. Looks like I have another question.
Yes, ma'am.
Do I just need to click on it, Kathy?
Yeah.
Okay. So it says, I'd like to confirm that Whitney accepts appointments from non-business owners. Yes. I do all sorts of clients. I do business clients. I do, everyday clients. I would say the bulk of my clientele is often, spouses or individuals looking to basically set their estate up. I try to cater to everyone in their needs.
So the other question is, somebody's just now typing, can a spouse be listed as an executor? And if something happens to the spouse,
You listed alternative.
can you list an alternative?
Absolutely. That's what I was sort of mentioning. So you can, of course, list a spouse as an executor and executrix, whatever the case may be. And I always, in my wills, designate, I call it the backup or an alternate, whatever words you want to use. But, you're spot on. Like, if your spouse passes, then who's going to handle this for you? Either your power of attorney, medical, or will. I always, in my planning, designate a backup.
So, I think, something that Whitney touched on that she might maybe want to go into a little more detail is listing your spouse as an executor if he's the father of your children, or she is a good idea. The challenge always is if they're not your children's parent. Right.
So when so you're touching on guardianship, and I get this too. So I was trying to tailor it more towards business, but I've got a little bit of time. Often I have young children myself, and so I wanted to provide or nominate who I wanted to take care of my children in the event I passed and my husband passed, and neither one of us were available. So, say I'll just talk about my own life at simplest. So say I had divorced my husband and I had remarried. Well, guardianship or really their father is going to have the entitlement to have custody of my children. I can't really circumvent that necessarily and appoint stepdad. Now, we're sort of talking about the other hat that I wear, which is custody. And I will say that there's caveats upon caveats to that sort of statement. But generally speaking, if both parents pass, you can certainly designate a guardianship. You can also, within a will, set up a trust so that if your kids are minors, that they can receive their property in a certain way if they're under a specified age that you want to elect. So I guess the short answer is really you can elect a guardianship, and who's going to take care of your kids. I think I've got another one.
Do you have another?
I have another question.
Yeah.
I'm sorry.
So, should I have a separate will for my sole proprietorship? That is a great question. Should I have a separate will for my sole proprietorship, or can it be combined with my personal will?
So you really don't have a separate will for your business. You as the business owner, you as the individual have your own will. And everything that you own, both your business, personal, and all of that together goes and funnels through that one will. You don't have a separate will for the business. Now, if you think of the operating agreement in terms of a will, that might be your sort of your end round to that idea. You know, your operating agreement could act as, I guess, a will. And that's putting it very loosely, but your operating agreement could say, upon my death, I want my shares to go to whomever, or I want to be bought out and the money given to my heirs. But in terms of a will, concretely speaking about a will, you only have one. You don't have one for the business and one for yourself.
And correct me if I'm wrong, but the reason for that is that if you have a sole proprietorship, you are the sole proprietorship. So if you die, the business itself dies and the assets become
Part
of your estate.
Yes, yes, that's correct. These are good questions.
We have that on a regular basis in the business challenge. People don't quite get that even though they're an individual and they have an individual bank account, and then they have a separate bank account for their business, they just don't get that they are the business and the business dies if
When they
die.
do.
Yeah.
And that's, I will say that tends to be one of the biggest issues we have is when, I think I mentioned early on, the client who had passed away and had multiple businesses. That client was the sole proprietor for many, many businesses. And so there were many issues with that, that there was just not proper planning done because they thought they had time. And so that sort of created a mess for the person who had to step in and act as executor.
So that's a good lead into the question. If you are an LLC, then does that change things?
So if you're an LLC, of course, it sort of depends on how you're set up. If you have many members or you have managers, however, the ownership is divided within the LLC. I mean, certainly you retain your ownership. So say it was me and you, Kathy, you know, I'd have 50%, assuming we're just doing equal shares to make it simple, but assuming I have a vested 50% interest in that company, then when I pass, my 50% has to go somewhere. And if it's not designated in an operating agreement, then by law, 50% of that company is mine and would go to my heirs and beneficiaries by law. Does that answer that question?
It does.
Okay.
Because then the shares don't die with the person.
No.
So, you know, and something that's really interesting is that a subchapter S corporation is not actually a separate entity. It's a tax entity.
It is.
So don't become a subchapter S. It's treated like a sole proprietorship, right? Upon your death.
Yeah. I mean, really any interest. I mean, when you think about your death, when we talk about ownership, it's not just the tangible things. And that's what I was trying to touch on earlier. It's intangible, your shares, your interest in perhaps a piece of property or the business. And in this instance, we're talking about businesses, but that's not a tangible thing we could look at and say, you know, that's what you own necessarily if there's no operating agreement. But anything you have an interest in, when you die, has to either pass through the will or the state decides where it goes. Do I have another question or?
So you talked about having a separate list
Yes.
of items
Yes.
that you wanted, that you could revise periodically.
Yeah.
How do you have to date it? Does it have to be witnessed? You said it has to be kept with the will. What's the legal?
Things for that. So if we're doing it that way, you have to keep, first of all, your will has to have this specific kind of paragraph in it that says, you know, this is my intention to maybe create this list. Don't go creating lists if you don't have this specifically in your will, because then we run into a whole other host of issues about holographic wills. And again, I'm not going to derail the whole conversation for that, but it is messy. So if you have this specific paragraph in your will that allows you to incorporate this list that you create a year, 2 year, a decade down the road, that list has to be in your handwriting. I advise my clients to sign sort of each notation, especially if there's a gap in time, and I advise them to date it. And, you know, you can notate the list at the top, you know, pursuant to my will. This is the list I want to give and start listing items. Of import, again, your handwriting. Be specific. It's personal property only. It is not real property. Okay. We're not talking homes or anything like that. It has to be personal property. $5,000 in cash, my grandmother's engagement ring, coin collections, guns, whatever that may be. And again, I will say there's caveats within this, especially when we come to guns and where the legislation may be on that issue. So I'm not going to, again, derail on that, but specific pieces of property can be granted in this way, but it has to be very specifically listed. I would sign and date each one if it were me, just because I wouldn't want any questions. Does that answer that question?
It doesn't have to be witnessed.
It does not have to be witnessed. Now your will does, but this list does not have to be witnessed in order to be effective.
This has to be signed in your hand.
Signed. I always have my clients sign, date, and be very specific with the description of property.
Any more questions? It's speak now or forever hold your peace. Okay, well, I think this has been a great session. Whitney has certainly made her PowerPoint very clear and concise, and you know, it created the questions that we all wanted answers to. So again, we thank Whitney for coming today. She's got a very busy schedule. I see it on a regular basis, and we are privileged to have her do our new knowledge today. So I appreciate that. Billy?
Thank you.
Yes, thank you, Whitney. This was great information. Very, very good information. You know, just kind of like some free attorney advice. You can't beat that. You know,
yeah.
Word that we'll have to have you again.
Well, thank you. I mean, I'm happy to help in any way I can. Like I said, I was speaking in broad principles and things.
Perfect.
And certainly I will say there's nuances to probably everything that I said today, but speaking in broad strokes, I think we tried to cover a good amount of information. And Jean's looking at me like I need to do something.
Tell people to follow you on Facebook.
Oh.
You do Facebook Lives.
Yeah.
Okay.
So in terms of me and accessibility, obviously my phone number and my email for my work is up there. I do Facebook videos. I'm a little unique in this area in that I do that. Please feel free. It's like the Pennington Law Firm PLLC on Facebook. You can follow me there. I post videos, tutorials, not only on family law, but on these, like I break it down and I do like 2 minutes on a power of attorney and 2 minutes on an advanced medical directive. And I have posted different informational videos on these very issues. So if today was overwhelming or you have a question, go to my Facebook page. More than likely I've covered it in some regard, but feel free to follow me and share my posts and I'm pretty active on Facebook. And I have a pretty good following and an audience to only be about a year old. And I'm pretty unique in that I'm one of the few attorneys around here that post videos like that that's informational in nature.
Yeah, that's awesome. Whitney, if you could send Sandy and I an email with your links to all that stuff, we'll be glad to send it out when we send out the rest of like the packet information that you sent.
Sure. It looks like I have another question. Oh. Thank
Oh,
you. I'm not sure.
Yeah.
Thank you. I appreciate that. It was my pleasure. Again, I don't want to overrun you, Billy. But thank you all. I could talk probably for hours on estate planning, and I tried to be concise and not bore you to death. So hopefully I didn't confuse you or overwhelm you. Certainly, please feel free to reach out to me. Be happy to make an appointment with you guys and go over some specific estate planning that would be more tailored to your needs.
Wonderful. Thank you, Whitney. And thank you, Kathy, for your time today and for sharing your expertise with us this afternoon. Also, thanks to each one of you for joining us today, for taking time out of your busy schedules to participate and learn more about estate planning basics for business. Our next noon knowledge session will be held on June 7th, and it's focusing on commonly produced Appalachian forest botanicals. This sounds really interesting to me. It will be led by Robin Suggs, Manager of Procurement with Appalachian Sustainable Development. This region of Virginia has some unique herbs that are in demand in the medicinal and cosmetic industry. So join us to learn the value of what might grow in and around your property. Also, I wanted to give you guys a heads up on a new series of new knowledge sessions that we are launching in July. All the sessions through December will focus on different tools and services that Google offers. So each session will focus on a specific product or service and how to use it to meet your needs for your business. Today's session has been recorded and will be available to view on the Virginia Highlands Small Business Incubator Facebook page, the Virginia Community Capital Facebook page, And if you go to YouTube/Noon Knowledge, there are nearly 200 workshop videos that are available on demand with lots of valuable information on various topics. So please join us and please share this with someone that could benefit from this session. Thank you, guys. Thanks, Kathy. Thanks, Whitney.
Thank you all so much.